And we are now live, Chairman.
Thank you very much, Christine. Welcome to Clearview Township's Committee of Adjustment this June 14th at 7:02 p.m. I'd like to begin our meeting by recognizing the First Nations, Métis, and Inuit peoples of Canada as traditional stewards and caretakers of the land. We acknowledge that Clearview Township is located within the boundaries of Treaty 18, the traditional lands of the Anishinaabe, Haudenosaunee, Teonatani, Wendat, and is the home of many First Nations, Métis, and Inuit peoples. As part of an intricate nationhood that reaches across Turtle Island. At this time of truth and reconciliation, we welcome the opportunity to work together towards new understandings and new relationships and ask for guidance in all that we do. At this point in time, do any committee members have a pecuniary interest arising out of the minutes this evening? Gord.
Thank you, Mr. Chairman. I would declare a conflict on file number 23-A09. That would be the Pitaway application.
So when we get there, if you'd kindly mute and close your little video feed, it would be much appreciated. Good, sir.
Okay, thank you.
Any other members? Seeing none. Do any committee members have an interest arising out of the minutes of the last meeting? Seeing none, can I get a motion to accept last month's minutes, which have all been circulated electronically to you? All in favor? Carried. The Committee of Adjustment this evening will consider 4 minor variances and 1 consent application. The Planning Act requires that a public hearing be held before the Committee of Adjustment decides whether or not to pass a consent or a minor variance. The public hearing serves 2 purposes. First, to present to the Committee of Adjustment and the public the details and background to the application, and second, to receive comments from the public and agencies before a decision is made. For each application, our wonderful Secretary Treasurer will summarize the proposal and correspondence on file. Planning staff will provide any other information that is relevant to the application. From there, the applicant will be asked to provide any additional information that is not currently in the file, followed by any questions from the members of the committee. Will the Secretary Treasurer please advise how, when, and to whom notices of the public hearings were circulated this last month?
Thank you. Notice for these applications was posted on the subject properties on or before May 30th, 2023, being at least 14 days prior to the hearing. Notice for these applications was also sent by mail to the addressed owners within 60 meters of the subject properties. Notice was also circulated for the applications to those persons, departments, and agencies likely to have an interest in the applications as legislated. Included with each notice was a legal description of the subject property and a description of the purpose of the proposed consent or variance. The circulations were provided in accordance with the provisions of the Planning Act, RSO 1990, Chapter P13.
Excellent. Then we will start with the first file this evening, consent file 22B13, 1935 Fairgrounds Road North, known as the BT Farm. Madam Secretary, would you kindly read out the application?
The subject application concerns lands municipally known as 1935 Fairgrounds Road North, formerly Nottawasaga, and legally described as Concession 4, West Part Lot 25. The purpose and effect of the application is to sever one surplus farm dwelling lot from the subject lands. Proposed severed lot, 69 meters of frontage on Fairgrounds Road North, overall 0.6 hectares, 1.5 acres with dwelling and accessory buildings. Retained parcel, approximately 182 meters of frontage on Fairgrounds Road North, overall 57.4 hectares, 142 acres with agricultural building. Comments were received by the chief building official and Hydro One, having no concern or objection to the application. We also received comments from the Nottawasaga Valley Conservation Authority, and I will read those now. Staff have reviewed this application as per a delegated responsibility from the province to represent provincial interests regarding natural hazards identified in section 3.1 of the provincial policy statement, PPS 2020, and as a regulatory authority under Ontario Regulation 17206. So they go on to state different regulations under 17206, and then they refer to the provincial policy statement as well. And speaking to that, the PPS defines development to be the creation of a new lot, a change in land use, or the construction of buildings and structures requiring approval under the Planning Act. And they state that the subject application proposes to create a new lot, which would constitute as development as it relates to determining consistency with the PPS policy. And then they speak to natural hazards regulatory, and MBCA policy recommends that lot lines not bisect natural hazards. In this case, the two hazards associated with watercourse running through the property. Where this is not possible, the MBCA recommends that areas be restrictively zoned, and further watercourse crossings would not be permitted. In their conclusion, the MBCA has reviewed the proposed consent application and based upon their mandate and policies under the Conservation Authorities Act, can support the application as proposed with the above concerns taken into consideration. And we have a recommendation from the Planning Department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves consent 22B13 pertaining to lands at 1935 Fairgrounds Road North, Clearview, subject to the following conditions. One, that the applicant meet all the requirements, financial and otherwise, of the municipality, including payment of the fee of $150 for each certificate of consent to be issued. Two, that the applicant provides a description of the land, which may be registered under the requirements of the Registry Act or Land Titles Act as applicable. Three, that any mortgage on the severed lands, parcel with existing dwelling, be discharged, and that the solicitor provide an undertaking in writing that this condition will be fulfilled. Four, the existing barn structure located on the retained parcel, the vacant farmlands, be demolished and removed from the subject lands. And five, that the retained parcel, the vacant farmlands, is conveyed into the same name as the current farmer or farming corporation, and that the solicitor provide an undertaking in writing that this condition will be fulfilled. And that is all I have.
Do we have a representative of the BDs for this file on the meeting this evening, Christine?
Yes, Christine Loft is in attendance, their agent, acting on behalf of the BDs.
Christine, do you have a presentation or anything to add to the file before the committee other than what's on there already?
Thank you. Good evening. I do have a PowerPoint, but I'll leave it perhaps to staff if they feel that the PowerPoint's required, or if there's enough information with the staff report for committee. I don't think that my PowerPoint brings anything new to the table.
All right. Nick, do you have anything you would like to add other than what you have prepared for the committee this evening?
Thank you, Chair. Nothing particular, just perhaps note that this application is also subject to two concurrent Planning Act applications, which was an official plan amendment as well as a rezoning. So those applications went before and were both approved. So this would be the third final application in kind of the overall process to have the farm consolidation completed. So just want to note that, but if you have any questions, I'm definitely happy to answer them.
Thank you very much, Nick. Are there any questions of either representative for this file from the committee? Robert? You're muted, Robert.
There we go. I'm just wondering on the demolition of the barn, if it's customary to put a time limit or anything on that condition.
Yeah. Oh. Through you, Chair. So typically the consent is conditional for, so they have 2 years to complete the consent. So it'd be a matter of 2 years. If they want to complete it on the next few months, they can, but they have a maximum of 2 years to complete, to remove the barn as well as complete all additional conditions. But if they go over that time, the approval would lapse and they'd have to come back for the consent.
Very good.
Any other questions from the rest of the committee members of either one of the representatives? Yes, Gord.
Thank you, Mr. Chairman. My question would be the retained parcel. Can it be used in the future in combination with abutting lands for further development of some sort in any way? So for example, if it's over 100 acres, can it be developed? Can it be resevered and developed?
Through the chair. So technically, if it was merged with an adjacent property and it was over they would have to merge something that'd be over 200 acres in total, because it'd be a minimum or 70 hectares.
Yes.
But the lands that are currently zoned, they have been rezoned to an AGER zone. So that would restrict any residential development on that parcel of land. So even if they did merge it and then resever it, that portion of land would still be prohibited from allowing a residential use on it.
So just to follow up, then you're saying residential use, but what about any other type of use? Like a barn?
So as long as it's still used for agricultural use, that's okay. The AGR is restricted for a residential use, with the intent being that the applicant wouldn't be able to sever this property, build a new house, continue to sever that one, and so on and so forth. So the PPS a provincial policy statement requires that the retained lands be rezoned to prohibit residential use in the future. And that's what the previous rezoning had completed.
Okay, and one further question. Would they be allowed to build a farm dwelling, but it would have to satisfy setbacks? For example, if they put another barn up for pigs, for example, it could be allowed, would have to allow the restrictions on the distance away.
In terms of, yeah, so any sort of structure on there for agricultural use would still meet all the applicable setbacks.
But they would be allowed to do that?
Yes.
Okay. Thank you.
Any questions, Dan, Mark? None? I have none. Can I ask for a motion to accept the file as read by Christine Gord? All in favor? Carried. The consent is accepted. Christine?
Thank you.
All right, sliding right along to our second file, minor variance 23-A07, 1454 County Road 42 by the Sega family. Christine, if you would like to read out what we have on file for them.
The subject application concerns lands municipally known as 1454 County Road 42, formerly Nottawasaga, and legally described as Concession 3, Lot 2, and Reference Plan 51R9541, Parts 1 and 2. The purpose of the application is to request the approval of the Committee of Adjustment for relief for the following. 1, Section 2.6.3A, to allow a swimming pool to be located closer to the front lot line than front wall of the primary building. 2, Section 212.1B, to permit a home occupation to be conducted outdoors. And 3, notwithstanding Section 212.1B and E of the Township zoning bylaw, the home occupation shall not occupy more than 1.2% of the total area of the subject lands and shall not occupy a total outdoor area greater than 1,250 square meters. The effect of the application is to allow for the installation of a pool associated with the home occupation for an outdoor dog training business with a pool and fenced agility area on the subject lands. We did receive comments from the chief building official and Bell Canada having no objection or concern with the application. And we have a recommendation from the planning department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves minor variance 23A07 pertaining to lands at 1454 County Road 42 on the basis that it meets the 4 tests in accordance with the Planning Act, subject to the following condition: that no more than 4 vehicles associated with the home occupation shall be permitted to be parked on the site at any given time. And that is all I have.
Thank you very much, Christine. And we do have a representative for this file on the call this evening. There they are. Both of them. Excellent. Do you have anything that you wish to add to the file that is not currently before us as a committee this evening?
I don't think so, no.
It's a fairly simple request based on what I read.
Yeah.
Are there any questions of the committee members to our applicants this evening? Is there any questions from our committee members to Mr. Ainsley? Robert?
Yeah, just curious where the 4 vehicle condition comes from.
Nick or Christine?
Through your chair, I'm happy to answer that. So in discussion with the applicants, it's understood that typically there'd be a maximum of 4 people visiting the site basically at any given time. So the idea was to, in order to put some additional limitations to match that in terms of the maximum people that would be on site at any given time, just to put a restriction on there to make sure that is limited in scope and that it remains as an accessory to the primary dwelling and that the scale of it wouldn't grow or exceed.
Okay.
Any other? Gord?
Just a comment, really. Laura and Brad, I think it's an exciting venture that you guys are doing. I'm actually a neighbor to the north of you guys. And we have no objections, as you probably already know. So I tried to get in there and meet you guys, but you weren't there. But anyways, I'm excited for you. And I think it's a cool adventure. And I look forward to seeing it work well for you.
Thank you very much.
Thank you.
We've gotten lots of positive feedback from other businesses and the people who have been here so far, and we're really excited too.
Good. Well, best of luck to you in the venture.
Thank you.
Thank you.
Any other questions of either applicant or staff from the remaining members of the committee? I have none. Can I get a motion to accept the file as read by our secretary? Mark, all in favor? Carried. Laura and Brad, you have a 20-day appeal period. And then my best advice to you is to go see Christine. Have a great night.
Take care.
Thank you.
Screaming right along to minor variance file 23-A08, 11019 County Road 10, Elliotson family file. Could you read it, Christine?
The subject application concerns lands municipally known as 11019 County Road 10, formerly Sunnydale, and legally described as Concession 6, Part Lot 17, and Reference Plan 51R42511, Part 1. The purpose of the application is to request the approval of the Committee of Adjustment for relief from the agricultural zone front yard setback requirement of 10 meters to 4.5 meters. The effect of the application is to allow for the construction of an addition to the existing dwelling on the subject lands. Comments were received from Bell Canada and the chief building official having no concern or objection to the application. And we also received a comment from the County of Simcoe. And their comment states that the County of Simcoe entrance bylaw number 5544 regulates the construction, alteration, or change in the use of any private or public entranceway, gate, or other structure or facility that permits access to a county road. The County of Simcoe has no record of an entrance permit being issued for the existing entrance from this property onto County Road 10. If the property owner cannot produce a valid permit, this entrance would be considered legal non-conforming. The county is requesting that the owner apply for an entrance permit in the interest of updating the status of this entrance. And we have a recommendation from the Planning Department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves minor variance 23A08 pertaining to lands at 11019 County Road 10 on the basis that it meets the 4 tests in accordance with the Planning Act. And that is all I have.
Thank you, Christine. We do have Shannon Elliotson on the meeting call representing her application. If she would like to join us, sort of in person. There she is.
Okay.
Do you
I'm
have
here.
do you have anything you can add to the committee members that is not already in the file before us that you would like us to know?
No, just something that Christine didn't mention. It is a porch that we are wanting to build in replacement of the mudroom that is currently, we call it a mudroom. It's a concrete step that they enclosed at some point. Other than that, the only other thing was that letter from Stephanie Taggart I think that's her name, Stephanie Thorne from the engineering department at Simcoe. Yeah, our property doesn't have a driveway. So, I mean, I don't know what to do about that. I guess I'll fill out an application for that.
So if I can, through the chair to Shannon. So they recognize that there is an entrance to the property. It's just that they don't have a record on file showing that there was an actual permit applied for. So
Yeah.
whenever they receive planning applications, they check their files, and just to keep their records in good standing, they would like you to apply for an entrance just to sort of somewhat legalize it, I guess. I don't think there's any concern there. It's just that they like to bring their records up to date, and so they have record that there is a valid entrance to their county road.
Right, makes sense. Okay, no worries.
So yes, you do have a driveway. Are there any questions of the committee members to the applicant? Gord?
My only question would be, what is the cost of that application? Perhaps Roslyn could answer that. Thank you.
Oh,
Mr.
thanks for the question. I actually don't know what the county would charge for that. But one comment I would have is that I don't know if there was these lands were actually subject to a consent of a farm out consolidation. So I'm surprised that there wasn't something done back in the day, because I think there was a actual road widening taken as well. So I don't know if Shannon, you were involved in that, or whether the farmer was, and
Yeah,
maybe
it was the farmer.
Yeah. And are you in touch with them? I just asked because if they possibly they may have records of the entrance, because if they took a widening, then chances are they had to recognize that there was an entrance there.
Yeah, I hear what you're saying. I will look into it. We do know the farmer that owns it. He's pretty to the books. So I know that he put an additional entrance on the fields that were severed from our property. So I can't see why he would have missed that.
Okay.
Yeah.
Well, and we can certainly have a look as well. I think the file isn't that old. So, I mean, I think I even quoted the file number. So I can certainly try to have a look as well. But anyway, if not, then it's always best to go and get it updated anyways.
And did you say a cost off the top of your head?
Yeah, I don't know the cost actually.
Christine has that answered.
Yeah, it's $100 for a residential entrance if that's what it's considered. It depends on the type of entrance. I'm not sure what they'll consider it to be, but I know that the residential entrance permit fee is $100.
And not that I'm playing devil's advocate, but if they missed it in their files, they might even do it pro bono just because they're catching up for their files. You know, that's just my thoughts. Does anyone else from the committee have any questions of Shannon or Roslyn on this file to build this porch? Seeing none, can I get a motion to accept the file as read by our secretary this evening? Robert, all in favor? Carried. Shannon, you have a 20-day appeal period just in case any of your neighbors want to get excited and slow you down. But my best advice is on day 21, go see Christine.
Thank you.
No problem. Screaming right along, minor variance file 23-A09. This is where Mr. Zagel steps out, correct? All right. 692921-22 Side Road, the Pitaway family file. Christine?
The subject application concerns lands municipally known as 6929-2122 Side Road, formerly Nottawasaga, and legally described as Concession 5 North Part Lot 21, and Reference Plan 51R14033 Part 1. The purpose of the application is to request the approval of the Committee of Adjustment for relief from Section 2.6.1.4, where a lot is less than 2 hectares, accessory buildings shall not exceed 200 square meters in area. The The applicant is requesting a variance to allow for an additional accessory dwelling of 42.6 square meters. And the effect of the application is to allow for the construction of a pool house on the subject lands. We received comments from Bell Canada and the chief building official having no objection or concern to the application. And we have a recommendation from the planning department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves minor variance 23A09 pertaining to lands at 692920 on the basis that it meets the 4 tests in accordance with the Planning Act. And that is all I have.
Excellent. And we have a representative of the Pitaway family, Bill and Robin, on our call. If you wish to join us.
Marie LaRue
Yeah.
is the agent and will be speaking on their behalf. Check as well.
Excellent. All right. Welcome, Marie.
Do I have to do, can you hear me?
We
I
can hear
can.
Marie. We just-
Okay. I don't know if the audio just doesn't automatically come on or no?
Your audio is on, but your video is not on, Marie.
Okay, all right. So, good evening. I'm Marie LaRue. I am a land use planner with Mountain Ridge Custom Homes. And we, on behalf of our clients, William and Robin Pitaway, have applied for the minor variance for them to be allowed an accessory building, which is 42.6 square meters, which is a pool house to go along with the pool that's being installed in their property right now. So the subject lot is a large lot. It's 1.58 hectares. It has 115 meters of frontage. And it is in the middle of an agricultural area and surrounded by farmland. So there would be no impacts or anything to surrounding uses. The zoning bylaw requires, when there's a lot in the agricultural less than 2 hectares, that the maximum accessory buildings is 200 square meters. And unfortunately, there's an existing large barn, which was retained on the lot, which has been, because it was structurally sound, I suppose, and it's been used for storage, but the barn itself is 702 square meters. And there was also a shed there. So the Pitaways have purchased the property and they've upgraded the house and addition and renovated. And so now they're looking to put a pool in, and the pool is going to be 50 feet west of the house. And so the pool house is really needed to provide with the pool somewhere to put all the utilities and a change room, as well as a covered sheltered area and seating and that for the pool. And so with respect to the minor variance, it needs to meet the 4 tests. And in my opinion, the proposal would meet the 4 tests, given the size of the lot, the size of the dwelling. Accessory buildings are supposed to be incidental and subordinate to the principal use. So the principal use is the dwelling, which is 464 square meters. And the proposed pool house is 42.6. Total lot coverage is allowed to be 20%. Well, it's only 8% on this lot. And so I think it's minor in nature and it's appropriate and desirable and would meet the 4 test. And so we're recommending the committee consider it favorably. And I'd like to thank you for your time. And if you have any questions, I'd be more than happy to answer them.
Thank you, Marie. Rosalind, do you have anything to add that we do not otherwise have in front of us this evening?
Thank you, Chair. No, I have nothing to add. Thanks.
All right. Are there any questions of either Marie or Rosalind from the committee members? None?
Okay.
All right, I'm going to assume that you're not having any questions, Robert, because your camera's off. All right, cool. Can I get a motion to accept this file as read by our secretary this evening? Robert, all in favor? Carried. Marie, your minor variance has a 20-day appeal period, and enjoy building the pool house.
Great. Thank you.
Thank you, Marie.
You're welcome.
Gord, you're allowed to come back now. Moving right along to minor variance file 23-A10 224 Mill Street based on the old family application. Christine, if you could read that out to us.
The subject application concerns land municipally known as 224 Mill Street, Creemore, and legally described as Concession 4, Part Lot 9. The purpose of the application is to request the approval of the Committee of Adjustment for relief from Section 2.6.1.1 and 3.9.2F to allow an accessory building to be located in an exterior side yard 1.62 meters, and from the Section 3.9.2K maximum gross floor area of all accessory buildings from 64 square meters to 78 square meters. The effect of the application is to allow for the construction of a carport on the subject lands. Comments were received from Bell Canada and the chief building official having no objection or concern to the application. And we have a recommendation from the planning department. Be it resolved that the Committee of Adjustment of the Township of Clearview hereby approves minor variance 23A10 pertaining to lands at 224 Mill Street, Creemore, on the basis that it meets the four tests in accordance with the Planning Act, subject to the following condition: that the cars parked in the parking area on the subject lands be set back 1 meter from the exterior side yard. And that is all I have.
Thank you, Christine. I'm going to assume that the last person on my computer screen, Shannon Dowdy, is going to speak on this file for the family.
Hi, everyone. Yeah, it's actually Abby Scott. I don't know why I came up as Shannon, but she's in my office as well. So sometimes you may see her. I don't have anything to add from what Christine has said in the report. Essentially, it's a carport for the house at 224 Mill Street, and it will be in their side yard. So we're just asking for relief.
Thank you, Abby.
Yes.
Rosalind, do you have anything to add that we do not already have in front of us in your report?
Nothing. Nope. Here for questions if you have any.
Any questions of either representative from the committee members? I am seeing none. Robert, say no.
No.
Perfect. If I could get a motion to accept the file as Christine has read. Yes, Gord, all in favor? Carried. Abby, there's a 20-day appeal period here in Clearview Township. And I thank you for your application, and I wish you well in the near future.
Thank you so much. Have a great night.
You too. That concludes the files we have before us. Christine, do we remain on YouTube for new business?
Yes, we do.
Okay. So the only point in new business I have is Dan, Mark, and I and Christine were at the wonderful seminar in Niagara Falls last week, and we were over a few dinner treats discussing some of the new things we learned. In consultation with Christine and reading Robert's rules of chairing a meeting, if you notice this evening, I continued asking for a motion as she has read them out. It is easier and clearer if we get into amendments or request to amend the original motion. If I stick with asking for a motion and then a vote on said motion. So I know we learned that we don't have to do that, but I'm comfortable with it, is what I'm saying. So I just thought I'd let you all know. It's the only new business I have.
Yeah. Further to that, Chuck, I did have a chance to discuss that with Amy today, and we do have a procedural bylaw. We use the same one that council uses, and they use the same format. So we would stick with what our procedural bylaw instructs us to do.
And they took theirs right out of Robert's rules of chairing a meeting, because it's word, I think it's word for word. But I knew we learned that the lawyer that, it was a lawyer, right, Dan, that was speaking?
No, it wasn't a lawyer. It was, I can't think of his name, that is up in Thunder Bay.
All right.
He was the one that was talking about that. There is a few municipalities that do not do the motions for requests and stuff like that. And it's not required because we're not a judicial committee. And that's the reason why we shouldn't be doing it, essentially, because we're not a judicial. So judicial just meaning that we don't have an AGM, we don't have financials of any kind. We don't have, all we're doing is judging a request. And so all we're required to do is make a decision on a request, not to have to follow the Roberts rules for that reason.
I talked to Christine and our fearless mayor this morning about this, and then I read the rules book again, and for me, it felt comfortable. The mayor did tell me about the township's procedural bylaw. He has no idea whether it pertains to us or not. He was going to look into that for me. But in the meantime, until such a time, I like doing it. It just makes it easier for the minutes, in my opinion. And Christine agrees with me, who takes the minutes. So I'm falling on her side, just saying. But that's all I have for new business. Any other new business out there? None. Our next meeting is Wednesday, July 12th, 2023. Christine?
Yes, it is. We will be meeting.
We have a few files, a lot of files.
We have 2 applications. Right.
A fine mid-July meeting it will be. All right. But I will not ask for a motion. We'll just close the meeting and adjourn at 7:39 p.m. It was wonderful seeing you all. I'm happy you all made it back from Niagara Falls. It was a